The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Welcome and welcome to the students from the international program at Drake Law School. We have 5 cases that will be submitted this morning. Those cases are in the interest of T.H., Robert Krogman versus State of Iowa, Bernard Willem and Patricia Ballack versus Shirley Campbell, State of Iowa versus Kasif Rashid White, and the final case is State of Iowa versus Johnny Ray Steiger. The last 3 cases are now submitted to the court without oral argument, and we'll now hear the arguments in T.H. Mr. Hindman.
Thank you, Your Honor, and may it please the court. I'd like to start off today by discussing the sex offender registration issue and whether that is unconstitutional under the federal and state prohibition on cruel and unusual punishments, and then time permitting, my intention would be to move on to whether the Court of Appeals erred in affirming T.H.'s adjudication. Obviously, I would take questions on anything at any time. With respect to the sex offender registration issue, I think there are a couple of big hurdles for T.H.'s argument here. The first and probably the biggest one, from my point of view, is whether registration or the registration requirement is punishment at all. And then the second is whether, if it is punishment, it's cruel and unusual, or at least the mandatory registration that's at issue here is cruel and unusual. And what I'd like to do is start out by first addressing this court's recent decision in State versus Graham and why it's our position that that case is not controlling here, because I think if we start by addressing that, that kind of answers those 2 big hurdles and shows why T.H.'s argument can get over those 2 big hurdles. Now, there are a couple of kind of easy ways or easy reasons to say why Graham isn't quite like this case here and why it doesn't control here. First of all, in Graham, the defendant there, Graham, was only attacking, as this court noted, the 2,000-foot residency requirement or restriction, as opposed to arguing that stigma or something to that effect is what caused the punishment to be cruel and unusual. And here, as is apparent from the opening brief that my predecessor in this case filed, the stigma is also at issue.
Well, let's cut through it just a little bit. I mean, I think Graham is quite limited, and he was at a residential center anyway, and so the 2,000-foot rule wasn't even implicated. But let's try the larger issue, and the larger issue might be phrased this way. We have held, at least in the past, on a number of occasions, that the sex abuse registration scheme was not cruel and unusual as to adults. And they all had varying fact patterns and kind of varying holdings. But in short, we had a number of opportunities, and we have not as yet declared sex registration as to adults is unconstitutional. Is there a difference with respect to sex registration with respect to juveniles? And if so, what is the difference and why is that important to us?
Yes, Your Honor, I think there's a couple of differences. First, there's a difference with respect to juveniles, and second, there's a difference with respect to juveniles who are adjudicated delinquent as opposed to juveniles like in Graham who are convicted. So even if this court were inclined to hold that Graham is perhaps more expansive than Your Honor is suggesting, I still think it should be limited to juveniles who are prosecuted in adult court as opposed to juveniles like T.H.
And why is that different? I mean, so you're absolutely right. Obviously, there was no criminal conviction in adult court in this case. But there was a juvenile adjudication, at least, indicating that your client was engaged in sex by force and against the will and so forth. And so Although the process was somewhat different, isn't the fact-finding rather similar?
The fact-finding is similar, Your Honor, but I think there's a couple of issues that tie in with the Kennedy versus Mendoza-Martinez factors that the court considers in determining whether or not the registration requirement is punishment. And like I said, I think that's the big hurdle that we have here, because I think once we get a resolution that, yes, in fact, applied to juveniles, these mandatory registration requirements are in fact punishment, I think it's inescapable that Lyle's
Counsel, Graham was at the time of our decision, he was still in the residential facility. Where is T.H. living now?
He is no longer at Four Oaks. I don't believe that's in the record, because I believe that transition happened after everything was filed in this case.
At the time when the dispositional order was entered, at the time the appeal was taken, he was in Four Oaks. Is that correct?
That is correct, Your Honor.
And in Graham, we said that where the juvenile was in a residential facility, in that case it was Fort Des Moines, he didn't have standing to challenge the registration requirements because it was kind of a moot point at that time. You're saying the record doesn't reflect it, but he's no longer at Four Oaks?
That's correct, Your Honor, but that's not really the heart of my argument here, because the defendant in Graham was only challenging, according to this court's opinion, the 2,000-foot registration requirement, and the brief that my predecessor submitted, I think, is broader than that, in that it talks about the stigma that flows from this registration requirement. And I think that ties back into a case that this court actually discussed in Graham, which is the CP case out of Ohio, where the court goes on at some great length to talk about just how significant the stigma of a registration requirement is. When you have, especially here, you have a Tier 3 offender who's going to have to register for a minimum of 5 years, even if the day that 5-year period expires, this registration requirement gets set aside, which I think is kind of a pretty optimistic approach on TH's perspective. He's still going to, until he's just shy of his 21st birthday, going to have to register. And like the court in CP stated, that means that he is going to enter adulthood with this millstone hung around his neck of having to register. And rather than ever having a chance to go into adulthood and to develop a reputation that is positive in the community, as a positive contributing adult to society, he will never be able to do that, because he's going to have to register, and it's going to be open and notorious that he's a sex offender from the day he's 18 until right before his 21st birthday, at least, when this 5-year period expires. So those first essential years of his adulthood, they're really going to be taken from him in the sense that he can't get his foot in the door as a productive member of society. And I marked something in this court's Lyle decision, which is a reference back to the court's Pearson decision, talking about a mandatory minimum that was at issue in Pearson effectively deprived the defendant of any chance of an earlier release and the possibility of leading a more adult life. Now, obviously, there isn't the confinement here, because we're not talking about a mandatory minimum prison sentence. We're talking about the registration. But that same reasoning applies. The possibility of leading a more normal adult life is going to be deprived from him for those first few years, and this is something that's going to follow him around forever. Whatever jobs he's in, wherever he's living, there's going to be this collective memory in the form of a stigma that's going to follow him around. And so that's why I think it's really inescapable that the reasoning of Lyle be extended to mandatory sex offender registration cases like this.
It's back to the issue of, is the registration punishment or not? We have repeatedly said it's not. And what's changed?
Well, what's changed is that here we have a juvenile who was adjudicated in the juvenile court system. And thank you, Your Honor. When I look at the Kennedy versus the Mendoza-Martinez factors, and in particular the final factor, which has been recognized as the most important, whether there's an alternative purpose to which the statute at issue may be rationally connected other than punishment, and whether it appears excessive in relation to that alternative purpose. Clearly there's an alternative purpose here. This court's recognized that. There's a civil alternative non-punitive purpose to these registration requirements. So the issue is whether the registration requirement, the mandatory registration requirement here, is excessive in relation to that alternative purpose. And perhaps it isn't with respect to adults, but it's our argument that it is with respect to juveniles, at least with respect to juveniles who have been adjudicated delinquent, as opposed to juveniles like in Graham who have been convicted of something.
Doesn't that argument, that's an interesting argument, but doesn't that kind of blend the question of whether something is punishment or not with the question of if it is punishment, is it excessive or cruel and unusual punishment?
I do think it does blend that, and I think that's what the Kennedy versus Mendoza-Martinez factors essentially require. I don't think there's any way to escape it. So really, I think the question is this court going to say, well, when it comes to determining whether something is punishment or not, are we going to consider this different group of people, these juveniles that are recognized in Lyle and Pearson and Null and all the other cases as being constitutionally different from adults in terms of sentencing? Are we going to extend that constitutional difference, say that constitutional difference also applies with respect to determining whether something is punishment or not? That's really, I think, what the key
Does any other jurisdiction anywhere recognize that registration is non-punitive or regulatory as to adults, but punitive as to juveniles?
Not that I could find.
Well, Ohio held that Ohio has long case law saying that as to adults, the Ohio statutes are non-punitive, but as to juveniles, didn't Ohio Supreme Court and NRCP make the distinction?
That wasn't quite how I read it, Your Honor. My understanding was that it was the enhanced registration requirements that were at issue in CP, both as applied to adults and to juveniles, were held to be punitive. It's possible that I misread that, and perhaps Your Honor is correct. But as I read it, and from what I've been able to find, I couldn't find anything like that.
Well, I may have the wrong case, but the central notion is that although there may be authority out there suggesting that as to adults, the registration type regimes are not punitive, children are different. And they're different in a number of ways. First, they're less culpable. Second, recidivism rates for sexual offenders that are juveniles are in fact low. And third, you kind of get the double whammy, which is that juvenile at the critical formative time. So all those wrapped together, I take it, provide at least an arguable ground for distinction.
That's exactly correct, Your Honor. This court was willing to cut its own path in Lyle, and that's essentially what we're asking the court to do again in this case. And like I said, it's just a question of whether that reasoning in Lyle and the cases that preceded it with respect to whether something is cruel and unusual are going to be extended to determining whether or not something is punishment. Because I think once you consider whether or not this is punishment with respect to juveniles distinct from with respect to adults, you get into all of that analysis that CP sets out, that this is much more onerous, this registration requirement with respect to the juveniles than it is with respect to the adults.
But what about the scheme that's really in the code section here? You know, they make provision for the fact that these are juveniles. I mean, we have a whole code section that talks about the treatment of juveniles when it talks about these registration requirements. And so the legislature's already taken into consideration that juveniles are different, that they're going to be treated differently, and the only exception to that would be that if it's by force or against the will, whatever the language is of the statute. So doesn't that already take into consideration the facts that juveniles are different, and they treat them different, and the statutory scheme treats them differently?
It does to an extent, Your Honor, and certainly the statutory scheme treats the juveniles differently, but I think the problem is it still is depriving the sentencing courts, or in this case, the court entering a dispositional order, from the freedom and the discretion to apply the Miller factors to make an individualized determination. It's still a deprivation of the individualized determination, which is exactly what this court said is not allowed.
So you're saying that in every adjudication of a juvenile for a sexual offense like that, they must go through the Miller factors and determine whether they should register?
Yes.
You're reading that into the statute then?
Well, I think that that's what is required to be applied to the statute. under the Constitution. So if the statute doesn't allow that, or if the statute doesn't allow that to be read into it, then the statute is problematic under cruel and unusual
And
punishment.
again, you see my disconnect a little bit with that in that when we talk about the Miller factors and the Lyle factors and all these things, it talks about punishment, it talks about incarceration. This is a little different. Wouldn't you agree?
This is different. I mean, certainly the court is going to have to engage in an exercise of line drawing, and where is that line? Is it on the incarceration side, or is this significant enough in the life of a juvenile, and is it detrimental enough that it's going to be considered punishment for a juvenile, even if it's not for an adult? It's our position that when you look at Lyle, you look at the reasoning underlying that, and you compare it to how this issue has been considered in cases like CP, you put all that together, Lyle has to be extended both in purposes of determining whether it's a punishment or not, and then once it's been determined to be a punishment, a little bit easier question that, yes, this mandatory regime without allowing consideration of the Lyle factors.
But isn't this registry statute less about punishment and more about protecting the public?
Yes, Your Honor. I mean, that's certainly what this court has recognized. But at the same time, even with that being the intent of the legislature, you still have to go through those Kennedy versus Mendoza-Martinez factors to determine whether the effect of this statute, even though its intent is non-punitive, is punitive enough that it becomes, in effect, a punishment for purposes of this constitutional analysis.
Well, you know, the Miller factors exist to try to determine whether the punishment is cruelly unusual, whether it's just too severe. If this isn't punishment to begin with, how do we apply those factors in this situation?
Your Honor, I see my time's expired. Can I go ahead and answer? If it's not punishment, then I don't think that we can win this case. I think that's the first question, kind of a threshold question this court's going to have to answer. Is this punishment as it applies to juveniles, or at least juveniles who've been adjudicated as opposed to convicted?
Thank you, Counsel.
Thank
Ms. Triick.
May it please the court. Counsel. TH is asking this court to extend and expand its cruel and unusual punishment jurisprudence beyond, I think, what is reasonable and in a manner which is clearly unnecessary to protect the constitutional rights of convicted juveniles and which would jeopardize the public safety. I also want to start with this antecedent question of whether or not punishment exists. Obviously, to find that something's cruel and unusual punishment, you must first find that it's punishment. And I think we need to not forget that this court has already considered that question.
But not in the context of juveniles, I don't believe. Correct me if I'm wrong, but in the context of juveniles, we haven't really ruled. Am I wrong?
You're not wrong. Pickens does not involve a juvenile.
Okay, and then I apologize to counsel. It wasn't INRI CP. It was Dull, the case from Kansas, where, so you were absolutely right, and I was wrong on INRI CP. But Dull in Kansas, the Mossman case ruled that as to adults, the registration scheme was not cruel and unusual, but the Dull court found as to juveniles it was different, right?
Yes, I believe that Pickens is controlling because it answers the exact question here, whether it's punishment. But even if it doesn't, I would like to point out a couple of things. First of all, I recognize that counsel for TH has changed, but the brief makes no argument here about why Pickens should be overruled or why it doesn't control. There's no recognition of why it should be found clearly erroneous by this court.
But they argue that as to juveniles, it's a different matter, and cite, you know, Miller and the other cases. I mean, aren't they basically saying, I mean, although the case cites might not be ideal, but the thrust is that while it may not be punishment as to adults, and we do have some cases that so hold, and nobody disputes that, but as to juveniles, the formula changes. And the formula changes because, A, as a general proposition, juveniles are less culpable, cite. B, the impact on a juvenile is just dramatic when you're talking about the formative years, the very formative years, the plastic years that Justice Kennedy has waxed eloquently about, or maybe somebody would dispute that, but at the very formative years, that's when the stigma and the imposition of the sex registration scheme really gives them a double whammy. So it's a different kind of analysis with juveniles, is it not?
I would disagree that it's more punitive or somehow worse to be on the sex offender registry when you're 15 than when you're 30. I don't know that we know that. I don't know that, particularly if these juveniles are in residential facilities as they are here, they're not trying to seek employment when you're 15 the same way you are when you're 30. And also, I want to make sure that we remember that we're not talking about all juveniles. We're not even talking about all juveniles who commit sex abuse by force or against the will. We're only talking about those who commit it by force, or involuntary drugging, or the threat of serious violence. So
what do you make about the argument was suggested at least that, well, wait a minute, this was a juvenile adjudication and not a criminal conviction. That fact is, of course, true. The suggestion is that, well, the juvenile system is designed to assist in the rehabilitation of youngsters and youth, and it's not exactly an adversary proceeding, et cetera, et cetera. And you heard the argument, but I'd like to invite your response.
Certainly. I think that I think the adjudication is sufficient to allow the registration, and I really think the only distinction here is actually to the juvenile's benefit. In Section 232.54, 1I, which is cited in the state's brief, there's a separate provision that only applies to juveniles who, out of an adjudication, were put on the registry, and allows the court to review that registration placement before the time of the termination of the adjudication, and can remove the juvenile at that point. So I don't...
And did that apply to TH, or could it have? Or not if he committed a forcible sex offense?
I don't think there's any case law on that point. It is our position at this time that it could have applied to him.
Could have applied? Explain how you think it could have applied.
Well, I think that the language there is broad, and it doesn't say it doesn't apply. Now, that question's not directly before this court, and there was no question below. TH did not try to, or at least yet, as of yet, has not tried to assert that provision of the code, but it doesn't say it doesn't apply.
Is this case even ripe then, if he has that option and he hasn't tried it yet? I mean, maybe the juvenile court could have granted relief, or still could. Then there's no mandatory minimum issue.
Correct. And I also think that there are other sort of standing issues here. As was discussed earlier, he was placed in residential treatment. He sort of makes this broad assertion that the whole registry is unconstitutional, but he hasn't shown that he had to comply with the 2,000-foot rule, or that it somehow caused him problems with employment. And so, and also he discusses, and I think there was some discussion among this court about recidivism rates of sex offenders as juveniles, and I don't think any of that is in the record here, and certainly we're not, again, talking about all juveniles. We're only talking about juveniles who are 14 years or older at the time of the offense and who commit it by force, by involuntary drugging, or by the threat of serious violence.
Well, it may be, but the notion of a 14-year-old being automatically placed for a mandatory period of 5 years. Now, I understand you have the argument you just made that maybe there's an opportunity to be heard earlier, but assuming that's not the case, mandatory 5 years on the registry, regardless of all the facts and circumstances, et cetera, is fairly daunting. Don't you agree?
I mean,
it's not individually tailored to the circumstances of.
This individual committed a very serious offense, so I'm not going to suggest that our response wasn't serious. I wouldn't want to be placed on the registry. It's a serious response, but this juvenile's actions demanded a serious response. And I don't think it is constitutionally disproportionate for us to attempt to protect the public safety, particularly when we're dealing with juveniles who this court have said don't make particularly good decisions. And we're talking about this juvenile between the ages of 14 and 19 or 20, depending on when his birthday was, having to register to protect the public safety of the other children of the state of Iowa. And I don't think that the state would apologize for that response to this individual's behavior. I do want to make sure, though, that this court remembers that there are two questions here. First, you have to ask if it's criminal punishment as opposed to a public safety act by the state. And even if it is punishment, if it's criminal punishment, then you still have to ask the question of whether or not it's constitutionally disproportionate, whether it's cruel and unusual. And TH's argument here is basically that it's so serious, it's basically constructive imprisonment, I believe is what he calls it. And the registry is, while onerous, is certainly not as serious as imprisonment. It's not even as serious as probation. And probation is what juveniles get in the other juvenile cruel and unusual punishment cases that this court has considered. This court has said that imprisonment and mandatory imprisonment is too serious for juveniles. So what they need is a chance at probation, either at the time of sentencing or at a time later on when they go before the parole board. But parole...
Of course, it depends on what the terms of probation are, I guess, but I'm struggling a little bit. Probation strikes me, and I want you to push back, but on the surface, probation strikes me as less serious than being put on the sex registration list where your name is available on the internet and you're a pariah. I think most people would say, well, I'll check in with my parole officer every couple of weeks rather than be on the sex list. But
checking in with your parole officer is not the only requirement of parole, particularly if you were convicted of a sex offense. Likely, most of the requirements of the registry, perhaps except the website, are going to be imposed. And I guess my reaction, as well as reactions of people I spoke to, were that it was less, but certainly it's a reaction as to whether or not you think one is more serious than the other. If it is a close question in your mind, then certainly the same argument applies. It's not incarceration. We're not talking about incarcerating juveniles for any period of time. TH was not incarcerated. He was sent to residential treatment, although that has to do with the juvenile delinquency and the manner in which we treat juveniles. And there are certainly many other considerations that went into this case and most juvenile cases that have to do with his parents' ability to supervise him and many other considerations which are not at issue at the time of a criminal sentencing. And I think that I do want to make sure that I also talk about this court's decision in Graham last session. If it's punishment, and if the sex offender registry is serious enough to warrant the kind of analysis that incarceration got in Lyle in the preceding cases, then I think for the same reasons that the lifetime special sentence was not cruel and unusual punishment as applied to juveniles, this registry here is not cruel and unusual punishment as applied to juveniles. Just as I've mentioned several times, discretion is available for for the vast majority of juveniles. It's just the small subset that we're talking about, and then the statute allows for modification. The legislature specifically considered juveniles as different and recognized their ability to be rehabilitated, but perhaps also the dangerousness short term, and set up a system that allowed for juveniles to get their registration modified if they can complete treatment successfully.
Well, but that registration modification is kind of extraordinary. It's 5-year minimum, number one. You do have to complete treatment, as you say, and then you have to have a stipulation from the Department of Corrections. I mean, it's not really a meaningful opportunity to be heard on the issue of rehabilitation, I don't think.
And I don't believe that juveniles it's a slightly different requirement for juveniles as to the Department of Corrections as opposed to, I believe you have to go back to the juvenile court if you've been adjudicated delinquent for the modification. But I don't know that that's extraordinary. If you can establish that you are no longer a danger to the public safety, you
So you're
should be able
saying
to
there
do
is-
those things.
I gather your view is that after the 5-year mandatory minimum, you're saying there is an opportunity to be heard to present evidence and at least argue that you ought to be taken off the registry.
Correct.
And that the provision, I may have misread the statute, the provision that seems to require a stipulation from DOC doesn't apply to juveniles. Well, we can,
Yeah, I mean, you
we'll
can read
check
the
it out.
statute. I believe there's
yeah.
a slightly different requirement for juveniles. They still need somebody to agree. I'm not sure it's the same people.
Didn't we say in Lyle and quoting Brugger that in determining whether a particular effect is cruel and unusual, the best, that the statutes themselves, the legislative judgments are the most reliable objective indicators of community standards?
Certainly, and I think that that applies both to the cruel and unusual analysis as well as to whether or not it's punishment. I think TH conceded here, and I think the case law is abundantly clear that the legislature intended this not to be criminal punishment. And so absent a strong showing that somehow that's sort of a disingenuous intent because you responded in such an outrageous manner, I don't think that.
Well, I don't think I mean, all of our cases, Ragland, Null, Lyle, are, kind of cut across legislative judgments. I don't think there's necessarily a declaration in any of those cases. I mean, we don't go after the legislature particularly for bad motives or some such thing. But we came to independent judgment that was different than the legislature. I mean, we've got 4, 5, 6, 7, 8 cases that do that.
Although those are cruel and unusual cases, not punishment cases, right? So it's a slightly different analysis. And I just wanted to end by pointing out that I think that this case calls for us to sort of take a step back and ask first principle questions about cruel and unusual punishment. Again, we first have to find that it's punishment, and it's well established in this court's case law for 20 years that it's not punishment. But even if it were, what we're really asking is if the state's response was so disproportionate as to be unreasonable. If I may quickly conclude, Your Honor. TH here used physical force to force IN to perform oral sex against her clear objections and resistance. As a consequence of that, he received treatment and was required to initially register on the sex offender registry. This is not an unconstitutionally disproportionate response. It's reasonable, it's appropriate, and it should not be held by this court to be an unconstitutional response to a juvenile's sexual offending.
Rebuttal?
Yes, Your Honor, thank you. With respect to the issue that Your Honor touched on with respect to Dole and CP, I believe the question that I got was whether there's any instances of any courts from any other jurisdiction saying that the registration requirement is punishment with respect to juveniles but not with respect to adults.
Well, doesn't say that, does it?
Not quite.
Because Kansas has a very different scheme from Iowa, and the Kansas Supreme Court has said it's punishment for both. It's just in their view unconstitutional as applied to juveniles but not adults.
Well, as I read Dole, Your Honor, what Dole's referring to is not the registration scheme. It's the essentially equivalent to the lifetime parole scheme that Iowa has, and that's what they were saying. Maybe that's not punishment for adults, but it is punishment for juveniles.
Point well
There is-
taken. Point well taken.
Excellent point. And in fact, the Dole does make the distinction between juveniles and adults.
With respect to punishment, I believe that's correct, Your Honor. I have Dole here with me. I didn't have time to read the whole thing as I was sitting there, but I think that's the difference. And I think even though it's a different issue with respect to the lifetime parole as opposed to the mandatory registration, I think the reasoning still shows that what we're asking here isn't as much of a shot in the dark as perhaps the state is applying. Now, with respect to another issue that counsel for the state talked about, community standards, both with respect to whether it's punishment or not and with respect to whether this mandatory registration requirement is cruel and unusual or not, that is actually something that this court touched on in Graham again in reference to CP, where CP, as this court stated in Graham, recognized that there was this essentially national foot-dragging campaign to say, hey, wait a minute, we don't want to comply with these national regulations about the sex offender registry because it makes all this juvenile stuff for kids who have been adjudicated, not convicted, public for everybody to see. And the result, as CP explains, is that in 2011, the United States Attorney General said, okay, you guys don't have to do that. That doesn't all have to be out there on the websites or the internet site or whatever. And so I think that national foot-dragging campaign that this court did reference in Graham is evidence of something to the effect of community standards or the type of consensus that the court looks for in these types of cases. Now, another issue touched on a moment ago was the difference between the juvenile system and the criminal system, and I think that really gets to the heart of both the question whether it's punishment or not and the question whether it's cruel or unusual or not. Because the issue is, are the standards applicable, which I would typically in a criminal case, the standards of punishment, are they being advanced or not by what's at issue here, which is the mandatory registration requirement. And I think we explain in our brief why, and the cases that we've been discussing today explain why the registration requirement as applies to juveniles is actually detrimental to the purposes generally of punishment, which would be especially rehabilitation, but in particular the purposes of juvenile court. And I think that again gets to why juvenile court and a juvenile court adjudication is different than a criminal conviction, even for a juvenile offender.
Speaking
Can
of
I
those,
shift gears and just, I want to ask, and maybe you were on the same track, Justice Waterman, I hope. There was discussion, and he asked some questions about, is there an escape valve? In other words, could your client have petitioned to be relieved from the registration requirements? And if so, has he done so?
I don't know of anything in the record that reflects that he has done so.
How about the first question?
With respect to that question, I don't think so, because 692A seems to all be mandatory language to me. Now, I agree with counsel for the state. I don't think there's any case law precisely on that. But when I look at 232.54 sub 1 sub I, what it says is there's still the potential escape valve comes at the termination of the dispositional order. So the 692A requirement shall be required to register still applies. There's still mandatory registration, at least for whatever the duration of the dispositional order is. So even
won't that end when the juvenile becomes an adult?
Yes.
All right.
So,
and then doesn't 692A 128.6 kick in and allow the juvenile to be relieved? So, because the scenario you're talking about is someone who's in their 20s and they're trying to get started and they can't, they're subject to this stigma. And my question is there a way for them to avoid that?
well, if, like I said, I read the 692A requirement to be mandatory, and I suppose it would be an issue that the court would have to decide, is that trumped by 232.54, but 128 says 5 years for a Tier 2 or Tier 3 offender, which is what we're talking about here. And so regardless of when, if that is what's applicable, and if that 5-year requirement in 692A.128 is not trumped by 232.54, then you've still got that 5 years, which is still going to continue.
Well, let's assume it is trumped. I mean, take a victory where you get it. I mean, it may end up, in order to preserve the constitutionality of the statute, or to make it, to not come close to the constitutional shoals, maybe we'll say, maybe, that there has to be a meaningful opportunity to be heard at the close of the dispositional order. If we held that, what would that do to your constitutional argument?
Well, Your Honor, I see I'm out of time. Could I go ahead and respond?
You may.
With respect to that, you've still got mandatory registration from the date of the adjudication until the termination of the dispositional order. So I don't think that really I mean, certainly that weakens our argument, because I can't say, hey, we've got 5 years and here's a kid who's 15 and he's going to be 20 before he gets out anymore. But he's still going to be, for the duration of his period under the dispositional order, out there on the internet site referenced in 692A and being a sex offender. And so maybe those same detriments apply to a lesser extent, but they still apply, and we think that's still enough to warrant an extension of Lyle. Thank you, Your Honor.
Thank you as well, Mr. Hindman. The case of T.H. is now then submitted to the court, and we'll next hear the arguments in Krogman versus State.